are the legal compliances for solar or wind land acquisition from a private party?
12 things you have to consider. So just make a checklist and write 12 things which you have to consider while solar land acquisition. So in case of solar land acquisition, there are certain registrations required. There are certain taxes which have to be paid. There are certain approvals which have to be taken. Number one is of a protected tenant or not. So every state has a different protected tenant. Some states will say, so you have identified a land, your land, what you have done is you have got an award from the government, and you also have identified, you have appointed a land aggregator. Please identify lands for us. You have identified land. First compliance, what you have to do, checklist. Number one checklist, you have to see whether this land belongs to a protected tenant or not. Who are protected tenant? Every state has different protected tenant. Some states say scheduled caste is a protected tenant. Some states say scheduled tribe is a protected tenant. Some states say domicile. If a person is resident of that state, he is a protected tenant. Some states says farmers are protected tenant. Some states says economical weaker section are protected tenant. So every state can define its own protected tenant. In that particular state, you have to first thing you have to identify who is the protected tenant. If the land belongs to the protected tenant, then you have to take approval from the collector, whether or the state government, that please provide me approval to buy this land for solar purpose. First compliance is protected tenant. Second compliance is land ceiling approval. So when land reforms was done after independence, 1950s, 60s, 70s, ceiling laws were made. Ceiling laws means that an individual or individual family can have limited acres of land. So in Uttar Pradesh, the maximum amount of land an individual person can have is 18 acres. So every state has a different ceiling laws. If you are putting up a solar plant of a megawatt or utility scale solar power plant, you will require large land. So it will cross ceiling limit. If you want to acquire 100 acres of land and the ceiling limit is 18 acres of land, then that additional land which your company has acquired will be very challenging. Registration will not happen of that land. So what you have to do is, second compliance which you have to do before registration is land ceiling approval. So every state will have different land ceiling approvals and you have to follow that land ceiling approval process. So I will give you one example. In Uttar Pradesh, land ceiling approval says that 18 acres no approval required. If you are taking up to 50 acres of land, you have to take approval from the collector of that district. If you are taking 100 acres of land, you have to take approval from the commissioner. If you are taking more than 100 acres of land, you have to take approval from the government of Uttar Pradesh Principal Secretary. So you have to, second checklist, you have to see land ceiling approval. After that, third approval will be stamp duty. So stamp duty is an indirect tax which is under the purview of the state government. State government will notify for what transactions stamp duties are applicable. In case of sale deed or transaction of documents, stamp duty is applicable. Every state has its own notification with respect to stamp duty. So under the Indian Stamps Act 1899, you have to pay full stamp duty for the land you are purchasing. In case of non-compliance, if you have not purchased the stamp duty, there are three things which can happen for non-compliance. Number one, the sale transaction will be inadmissible in evidence. That means you cannot show it anywhere as a proof that you are owner of the land. Secondly, if you have not paid adequate stamp duty, 10 penalty up to 10 times will be applicable. Third, the transaction document can be impounded by any authority. This is the implication of non-payment of stamp duty. All right. So across India, the act is the Indian Stamps Act 1899. But every state government has its own amendments and its notification where stamp duty is mentioned. When I call stamp duty, then you have to take care of 4 things. Number 1, stamp duty. Number 2, what is the surcharge applicable on stamp if the state government has imposed a surcharge? Number 3, you have to see what is the registration fees. Number 4, you have to see copying, scanning and indexing fees. These 4 fees, some states will only provide stamp duty. Some states will provide stamp duty, surcharge or registration fees. Some state will provide all 3. Some state will provide all the 4 things. But it is notified by the government. So third compliance which you have to do, it is an indirect tax which has to be paid. It is called stamp duty. Fourth compliance which you have to do is land registration. Land document, transaction document registration. This document registration is done under Registration Act 1908. So section 17 of the Registration Act 1908 clearly specifies that all property transaction above 100 rupees have to be registered. What is the implication or result of non-compliance or non-registration? There are 2 implications. Number 1, it is inadmissible as evidence. Second, it can't be used as collateral for loans. So the project, if your land documents are not registered, project is not bankable. So fourth compliance is land registration. Once you do land registration, fifth compliance is mutation. It should be transferred in your company's name. So registration does not mean that government has recognized that this particular land belongs to you. Registration only means that 2 parties have transacted together. After registration of the document or sale deed, you have to go to the revenue authority and give an application that in the revenue record, please transfer the land in my name, my company's name. It is called mutation, namantran. All right. Next conversion, which is important, next compliance which is required is called non-agriculture conversion. In agricultural land, solar plant is not allowed. It is illegal to have a solar plant on agricultural land. Solar plant is an industrial activity. Hence, you have to file an application with respect to every state. Every state has its own land revenue code. You have to see in land revenue code under which section you have to apply for non-agricultural conversion. For example, in Karnataka, section 109, Karnataka Land Reforms Act 1961 says non-agricultural conversion. So you have to give an application, please convert it to a non-agricultural land. Once it is converted to non-agricultural land, thereafter you can start building the solar plant or you can set up solar plant. All right. Next compliance is annual land tax. So there are 2 things. One is lagan, which is land revenue, and one is land tax. Both the powers are with the state government. When a land is agricultural land, then you have to pay land revenue. So when you are taking land from a farmer, you have to see whether he has paid all the land revenues, lagan. Once you convert it to a non-agricultural land, the state governments have power to issue notification for land tax for industrial area. If the government has not issued any notification with respect to land tax, then no land tax is applicable. But you have to check whether land tax is applicable or not. Land tax is a direct tax and we have an indirect tax which is called stamp duty collection. Okay, all right. So 5, 6, 7. Eighth compliance is registration. So registration with central government. Registration with the central government is with CEA, Central Electricity Authority. It is a lifetime registration. Once you have prepared a DPR of a solar power plant, you can go and register. Once you have an award, you can go and register with Central Electricity Authority. It is called eGen portal. So if your power plant is of utility scale, 500 kilowatts above, 0.5 megawatts above, it is compulsory to get yourself registered. If you don't get yourself registered, what is the implication? Implication is that you will not get grid connectivity. It is mandatory for getting grid connectivity that you should be registered. And it is compulsory to register. So one is registration with the central government. Eighth compliance. Ninth compliance is registration with state nodal agencies. Every state has its own nodal agencies. In case there is any disbursement or approval required, or there is a concession in the stamp paper, concession in registration fee, concession in land conversion, it will be done by state nodal agency. So next, you have to register with state nodal agency. Can somebody give example of state nodal agency in their respective state? Who is the state nodal agency for solar power plants? These are the nodal agency. These are 9 compliance. 11th compliance, 11th checklist is section 68 approval. Approval for setting up overhead dedicated transmission line. So you will also require maybe 1 kilometer, 500 meters or 2 kilometers dedicated transmission line. You don't require a license for that, but you require a approval from the government for setting up tower bases. So section 68 approval is required for dedicated transmission line. All right. 11th approval is in case a private land is there and you want to enter private land, he is not willing to share, he is not willing to give you that land for transmission line. Then you require section 164 powers, notification from the government. So you have to decide whether you have to enter a private land or you don't have to enter private land. Then section 164 powers to enter private land, you have to acquire from the state government. 12th, right of way. So your solar plant, you are setting up a solar plant in 100 acres. But that area was a footpath for a villager. That area was a cattle path for a people who are residing around the area. That area, 100 acres, was a temple path. Somebody had to cross that land and go to the temple or go to the river or to the well. You have violated their right of way. So two things. One is solar plant access. It is, you have to have right of way to solar plant. You have to access solar plant, number one. Number two, you require right of way for dedicated transmission line versus right of way of the community. Solar plant right of way plus right of way of the, if solar plant has a right of way, the local community also has a right of way. So a simple solution for that is Gram Panchayat NOC. So whichever village is effective, 1, 2, 3, you go to the village that we are setting up a solar plant plus dedicated transmission line. They will give you a NOC. Okay, we don't have object because you are developing our village. You are a good neighbor. You will sit silently. You will develop our villages. So, okay, we are ready that our right of way will be affected. No worries. So Gram Panchayat NOC is the 12th. These are the 12 compliances checklist. One by one you have to do.